Hi, welcome back to Wicked Wise. So as I said in my last video, we're going to go over some of the 154 cases. We're not going to make it through all of them today, but wherever I stop, I will pick up in another video. So the first one is BLACKBURN versus Alabama, 1960. And it talks about coercion. Coercion can be mental or physical, right? So if they say, oh, if you don't sign the safety play, we're going to take your kids. Well, that's coercion. That's a threat. That's duress. Okay? So just remember that. Look these cases up, and I'll put them in the description below. The second one is if the statutes for abuse and neglect conflict with the Fourth Amendment, they must be deemed invalid. So if they're violating your Fourth Amendment right to privacy for just an allegation, it's not a true allegation, and it also conflicts with the Fourth Amendment, and that is Stanley versus Illinois. I'm looking down because I'm reading. The next one is the assumption that drug use constitutes abuse inappropriately shifts the focus from the welfare of the child to the behavior of the parent. That is DOLGIN. And that was, well, it doesn't say what year it was, but I'm going to put everything in the description below and you can look these up for yourselves. A trial court cannot terminate a parental right absent the finding of unfitness. Parental deficiencies alone do not render a parent currently unfit. If the parent can meet the basic needs of the child, which is health, welfare, and safety, they are not considered unfit. And that is parental rights. And that one was in 2016. The court explained, absent tangible evidence of abuse or neglect, the courts cannot and do not authorize fishing expeditions. That's when you invoke your Fifth Amendment right to just shut the fuck up, right? Don't answer their questions. And if you do answer their questions, answer them with a question, right? If they say, well, we're here because we got a report, then you ask them what the report says. It is your right to know. Other than that, tell them to get off your property. That case is North Hudson DC DYFS versus the Kohler family. Any officer who obtains a warrant through materially false statements which result in an unconstitutional seizure may be held personally liable for his actions under Section 1983. That case was in 1998. And it's Matos versus Davila. Number 8, defendants cannot lawfully seize a child without a warrant. Defendants cannot seize a child without a warrant, which is also known as a removal order, or the existence of probable cause to believe a child was in imminent danger. Go back and read imminent danger. Or not read, watch my video. The next number 9, oh, that one is WOOLEY versus the city of Baton Rouge in 2000, my bad. This case is Skowinski versus KRAMER. And it says, the fundamental liberty interest by parents in the care, custody, and management of their child. And interest must be balanced against the state's interest in protecting children suspected of child abuse. Number 10, to act under color of state law means a social worker acted beyond the bounds of their lawful authority. Number 11. An unreasonable belief of imminent danger to a child will render a seizure unreasonable. WALLIS versus Spencer. The right to procedural due process violated. The state denied the plaintiff the fundamental right to a fair proceeding before having children removed from their home. That is Morris versus Dearborne, 1999. The forced separation of a parent from a child, even for the shortest time, represents a serious infringement upon the rights of both. That means the parent and the child. Washington County. That one is Washington County in 1997. The loss of the First Amendment freedoms, even in a minimal period of time, unquestionably constitutes irreversible injury. That case is ELRODV versus Burns, 1976. So look how far back these are going. Parents, this is number 15. Parents and children had a clearly established liberty interest in association together. Okay? You heard that, right? That one is WHISMAN versus RINEHART. The next one is People versus Bennett. In revising the conviction of a teacher who violated the law, the court held that due process clause protected the powers of the parents to control the education of their own children. So don't let them tell you that you can't homeschool your kids. That's absolute bullshit. This case was decided in 1923. The last one I'm going to do is number 17. The right to the preservation of a family integrity goes above CPS. And that one is DUCHESNE versus SUGARMAN. That too was decided in 1977. So I'm going to put these cases up in the description. I want you to look at them. I want you to look them up. I want you to read them. If you want a copy of this, email me. I have it right on my phone. It's right on my phone. All I got to do is hit the button. It opens up. I can send it to you. 24Tiffany, TIFFINI, @gmail.com. And with that, have a great day.